The Shahi Imam of Jama Masjid has made an emotional plea to Prime Minister Modi to understand issues from the perspective of the Muslim community. I'm Barkha Dutt, you're with the Mojo Story. This emotional appeal from the Shahi Imam of Jama Masjid for the Prime Minister comes amid growing tensions that have been taking place over whether there are temples where mosques stand today. This is a controversy that has now taken over more places of worship than Gyanvapi and Mathura. In fact, areas like Sambhal and even the Ajmer Dargah have been pulled into this quagmire. Many people believe, looking at the tensions and the images of violence that we have seen in Sambhal in Uttar Pradesh, that this is the Pandora's box that has been opened mistakenly by the Supreme Court itself when it allowed the Gyanvapi petition. If you remember, when the Supreme Court delivered the Ayodhya verdict granting the Ram Mandir at the place where the disputed Babri masjid once stood, it invoked the places of worship legislation, a legislation that froze the religious nomenclature of places of worship as of 15th August 1947, with one exception, that of Ayodhya, because it was a dispute that preceded Indian independence. The places of worship law was passed in 1991. But this past week, there has been new controversy after Justice Rohinton Nariman, also a Supreme Court judge himself, criticized the Supreme Court but reminded the judiciary and the political class that the Ayodhya verdict did invoke that Places of Worship Act and that should be read to every district court in the country that is today allowing petitions that reopen whether a temple once stood where a mosque stands today. Let me introduce a very special guest today, one of India's finest legal minds. He's, of course, a senior advocate. He's a scholar and a thinker. Raju Ramachandran is with us. Mr. Ramachandran, in the interest of disclosure, is also appearing for one of the Muslim groups in the ongoing legislation in the courts around the Places of Worship Act. There are groups that have approached the court and have said that this act should be scrapped. Thank you very much, Raju Ramachandran. Always a pleasure to talk to you. Let me start by asking you what you made of Justice Rohinton Nariman's very, very scathing commentary, both on the Ayodhya verdict itself, but also on the fact that that verdict did invoke the Places of Worship Act that's since then seems to have been all but forgotten by local courts that are admitting petition after petition on whether temples once stood where mosques stand today.
Good evening, Barkha. Happy to be on your show again. Now, Justice Rohinton's Nariman's speech was timely. It was timely because it not only reminded courts below, but it reminded the Supreme Court itself of what it had held in the Ayodhya judgment. Why it is important to remind the Supreme Court itself is that the Supreme Court, after holding up the Places of Worship Act as an exemplar in that very Ayodhya judgment, saying it gives effect to the basic structure of the constitution, that it embodies secularism, still found it fit to issue notice on a slew of petitions which challenged the validity of the act. Once the 5-judge bench had held up this act as a model, then the Pandora's box was first opened by the Supreme Court issuing notice on these petitions challenging the constitutional validity of the act. Gyanvapi comes later, and therefore I salute Justice Nariman for speaking so powerfully and eloquently on this issue. He always calls a spade, and he's done it at the right time.
How would you describe the efficacy or the applicability of the Places of Worship Act today when we have seen the petition on whether there was a temple at the Sambhal mosque, the trial court, till the Supreme Court and the Chief Justice actually put a stay on that report being made public? The trial court did allow a local survey to take place. A local court in Rajasthan has admitted a similar petition asking whether there was a temple where the Ajmer Dargah stands. And this is a dargah where not just Muslims but Hindus also go and pray, as do people of other faiths. How would you describe the Places of Worship Act today?
The Places of Worship Act by itself is a very clear piece of legislation. But the
Mhm.
fact that a legislation exists doesn't mean that a petitioner won't go to court. So the burden is heavy on the courts to apply the Places of Worship Act strictly. And therefore,
Mhm.
whenever such a suit is filed, it is the duty of the concerned court to try this as a preliminary issue as to whether the suit would lie at all, whether the suit was maintainable at all in the light of the Places of Worship Act. Now, unfortunately, especially after those oral observations of the Supreme Court in the Gyanvapi case, courts have felt free to entertain such petitions and suits, to appoint surveyors, to appoint commissioners. The point which needs to be understood, which needs to be made loud and clear, is that once this Places of Worship Act put a freeze with effect from 15th August 1947, with the exception of Ayodhya, as you yourself pointed out, after that, there is no curiosity jurisdiction, there is no jankari jurisdiction in the courts for the courts to entertain petitions saying someone wants to find out if there was a mosque, find out to what purpose. This is not an academic exercise. To find out whether something was here or there is the job of the Survey of India, not the civil courts. And therefore, the courts ought to strictly apply the law by first trying this as a preliminary issue. And at the risk of
Mhm.
repetition, I say, unfortunately, a wrong signal has gone from the Supreme Court. And it's now time for the Supreme Court, in the cases pending before it, and that will be our submission to the court, to apply this act strictly, to issue guidelines to all the courts below. Because, as I said, nothing can stop a random petitioner from filing a suit. How do the courts then go about it? So, the guidelines will have to say specifically that when such a suit comes, first try as a preliminary issue the question whether the suit is maintainable or not.
Can I ask you though? The fact is that you say that the Places of Worship Act is a very clear legislation, but the burden is on the court now to, and especially the Supreme Court, to issue guidelines to local court, to trial courts on how to respond, or how to what is the appropriate legal response or constitutional response to a petition that reopens the Places of Worship debate. But given the precedents that was set in the Gyanvapi case, because there too, the petitioners or the Muslim groups did argue that the Gyanvapi petition was a violation of the Places of Worship Act, and then Chief Justice Chandrachud, he observed in open court that he did not think that a mere sort of interim survey violated the Places of Worship Act. Now, given that he has said that, that is the message that most local courts have taken away.
Yeah, one can only say, I wish he hadn't said that, because in
Hmm.
matters of such great moment and importance, even in their oral observations, the courts should weigh their words. And it is a matter of disappointment that a fine judge like Justice Chandrachud made those observations. But it's not too late. Now the court is sitting to squarely hear the issue of implementation of the act on the one hand, and the challenge to the validity of the act on the other hand. So we go beyond those oral observations. This is the time for the court to make written observations and clarify the law once and for all. What has happened. But that was just one oral observation.
Do you
It's
believe that?
time now. Yeah,
Do you believe that
it's
given the
time
slew
now
of
to make things clear.
yeah, you're saying it's not too late, but the cynics would say that given what we've seen happen in Sambhal, given what we've seen happen in Ajmer, now there is a debate even around the Jama Masjid in Delhi, and today we have the Shahi Imam making a personal appeal to the Prime Minister. Do you think the Places of Worship Act has been rendered redundant?
If the court doesn't step in now,
Yeah.
I'm afraid it will become redundant. But it is the duty of the courts to uphold and enforce the laws. A law shouldn't be allowed to pass into a state of disuse. And in the light of the very encouraging order which was passed by the Supreme Court in the Sambhal matter, I believe that the Supreme Court has realized the seriousness of the matter. And so I have the hope that things will be set right.
You do remain optimistic, but there's another way to look at this debate. There are scholars like Faizan Mustafa, for example, who argue that these debates cannot and must not be resolved by the judiciary. For example, on Gyanvapi, he has argued that the Muslim groups, and he's a Muslim, have a weaker case than they had on Ayodhya. And he feels that a dialogue between religious leaders or civil society leaders of both communities is the best way to reach some sort of final negotiated settlement, that if these ABC places are really worship to you, we either allow prayers to take place there, or whatever they negotiate, and then after that a red line is drawn and both communities agree no far and no further. Do you agree with that approach, or do you think these debates have to be settled by the court itself?
With respect to Professor Faizan Mustafa, I hold him in high regard. I think that's a very naive view. And that stage has gone. When could such debates have taken place? They could have happened. When could such dialogues have taken place? They could have taken place before the demolition of the Babri masjid. And I have argued in a piece yesterday in The Wire that the original fault was of the Supreme Court in allowing the demolition under its own nose. If that had not happened, there was scope for community dialogue. The atmosphere today is too polarized. Can you imagine a situation like, for instance, a few months back, Mr. Najib Jung, Mr. S.Y. Qureshi, and 3 or 4 other prominent Muslim public figures called on the RSS chief with a view to having a dialogue. But they didn't win the trust of the Muslim community itself, because the situation on the ground is so different. How do you inspire hope? And how does the community empower its leadership to negotiate? There's no scope today in this present polarized environment to have some kind of a truth and reconciliation commission, a grand understanding. No. The point is, Barkha, law sometimes has to lead society. Now, for instance, Prevention of Dowry Act.
Yeah.
Or before that, the law banning sati. Later, the Supreme Court's judgment recognizing the rights of transgenders, the 377 judgment. The court sets a tone and then society begins to accept. Now, for instance, as far as gay rights are concerned, I'm not talking of gay marriage, I'm talking of gay rights. Society is far more understanding, I would say, after the Supreme Court's judgment in Navtej Johar. So these are matters where the court has to take the lead, and especially when there is a law. This is not something where the court is being asked to be proactive. This was the legislative policy. The law has said so. And therefore, it is the duty of the court to enforce the law in letter and spirit. Dialogues can take place, but you can't displace the act, and you can't say that the court shouldn't come in at all at this stage.
So you believe that in this sense, the first duty or obligation of the Supreme Court is to uphold and protect the Places of Worship Act, which is a law that already exists, and its sanctity needs to be preserved. But a final question: you and Justice Nariman have revisited the Supreme Court response on Ayodhya. But let me take this further, because that's now in the past. The Ayodhya verdict is here. The Ram Mandir is built. It has been welcomed by, not just the BJP, but by several politicians across political affiliations. Looking forward, the Supreme Court seems to be guilty of mixed messaging. The Ayodhya verdict did underscore the Places of Worship Act not just as a law, but as a law that fell within the basic structure of the Constitution. In
That's
other
right.
words, tomorrow, if the Parliament wants to pass another law, the Supreme Court, in its Ayodhya verdict, argues that this is the basic structure, you can't just change it.
That's right.
But in
That's right.
Gyanvapi, it doesn't treat the law as a basic structure. It kind of says, oh, we'll come to that later. Right now, this is just an interim survey. The worry is if these kind of surveys have a domino effect in small towns, in small districts, we could be headed for acutely turmoil and strife-driven times.
I fully agree with you, and that's why I repeat, this is the time for the court to step in. The case is coming up next week, and it's coming up before a special bench. That itself, according to me, is an indication that the court is conscious of the seriousness of the problem. So one can only hope for the best.
As a lawyer in the case, a final response on what you hope on behalf of your petitioners.
Yes, since that disclosure has been made, I hope that the Supreme Court will accept our plea to strictly implement the law and by issuing certain guidelines so that there's no ambiguity as far as the courts below are concerned, that they are not in any doubt about how they should proceed with cases which come before them. The courts below should be very clear that they can't entertain claims just because someone is curious to know whether there was a temple.
Yep, I do believe that. Yeah, sorry, go ahead. No, go ahead.
No,
go ahead.
that's fine. That's fine. I completed what I said.
No, I was just going to say that the mixed messaging by the Supreme Court has indeed sent ambiguous signals down the line. And I think what's very important is most of these petitions do reach local courts. And that's where the messaging has to go down. It will be a critical next week. And Raju, I'm sure we'll get the chance to have you back when we have more sort of messaging from the Supreme Court, more clear messaging, we hope, from the Supreme Court. Thank you so much.
Yes, I hope so too. There must be a clear message. Yes.
Thank you. Thank you, sir.
Thank you. Thank you.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.